ICABA. ICABA is an organization, stands for International Career and Business Alliance, and it is an organization that encourages networking opportunities among professionals. Keith and I have the pleasure of being part of ICABA. Both of us are members. I helped charter the Atlanta chapter of ICABA about a year and a half ago. And ICABA does some fantastic things. Among them are educational opportunities. Even in the midst of COVID, they've had to pivot from in-person opportunities to webinars and other online and digital opportunities to continue to present the fantastic educational aspects of the organization. One of those is this webinar on estate planning that we do the third Tuesday of every month. We have done this session on powers of attorney. We've done the one on healthcare directives. We've done one on how to have those critical conversations with your families. And we thought we'd start off the new year talking about what a will is, go to the back to the basics of estate planning and go from there. So Keith, it looks like we are recording, correct?
Yeah, we're recording. And also I want to add for those on here, Shannon and I have a mastermind group. ICABA has an ICABA World. If you go to ICABAworld.com, there's a mastermind, a bunch of mastermind groups on there. We had one for estate planning, so we would love it if you would join and get information, articles. We post some of these webinars on there, so just a lot of information, and we're trying to build it up where it becomes a resource nationally. So we're still in the beginning stages, but ICABA has given us a venue for trying to grow some opportunities for getting information out to the public. So we really appreciate that.
What's the site?
ICABAworld.com. No space.
Yeah, let me put that in the chat window here. Or no, I'll put it in the Q&A.
Thank you.
All right. So given that we are going back to the basics of what estate planning is, and we know, because both of us practice estate planning law, we know that most people have a bare minimum understanding of what estate planning is. And generally speaking, that bare minimum is they have heard about a last will and testament. And so to start off, we're going to talk for 2021, we're going to talk about what a will is and go from there. Just a second, I'm typing this in the web. All right, so what is a will? How does it work? We're just going to start there. And I want to just point out our puzzle pieces. I like to think about estate planning in terms of putting together a puzzle. And I would venture to guess that everyone on here at some point in life has put together a puzzle. And you would have found it incredibly difficult and challenging to do that without a picture or a roadmap of what you want it to look like. And so estate planning is your opportunity while you are living and of sound mind to put together that picture that goes on the outside of that puzzle box, so that when something happens, like the possibility of becoming incapacitated or the certainty of death, when either of those happen, your loved ones or the people who you leave behind can pick up that box and they know exactly what that picture is supposed to look like because you've put together the pieces for them in the right order. So let's talk about what a will is, and are there different types of wills? So essentially a will, and I'm just going to go through this, Keith and I are going to do some tag teaming on these. So a will is, sometimes it's called a last will and testament, which I'm sure everyone on here has heard of. And it is the document, a legal document that says, these are my final wishes. Upon death, this is what I want to happen with all of my assets. This is what I want my legacy to look like. This is what I want that puzzle, that roadmap to look like. It then goes to a county court system. In most jurisdictions, that's called the probate court. And that would go to the court where you are domiciled at the time of your death. All right. And then the court is the one who reviews it. Different courts, different county probate courts have different systems and structures in place, but they review it essentially, and they make sure that your final wishes as detailed in that last will and testament are carried out.
And Shannon and I, we talked about this, sometimes in the movies they get this big scene where everyone gathers in the office and they read the will and act like that's some kind of official thing. And that's not the case. You have to take that document to a court, and that court has a process for letting everyone have notice, the potential heirs, and people can say whether or not they have another version or whether the person was in their right mind or not, and go through this whole thing. So just to get those Hollywood notions out that you can do all this in an office, you will go to court if you have a will.
Yeah.
So the second thing we point out too, and this is very important for anyone with a minor child or children, the only place that you can designate a guardian for your children that are minors are in a will. Even if you have a trust or some other document that you write it down, it has to be in a will. And that provision also only is going to take effect for the surviving parent's will. So if you are the first parent to go, the second surviving parent is automatically going to be the guardian, the natural guardian. So sometimes people think, well, I don't want that parent to, if they don't get along well, think I don't want that parent to have guardianship over my child. Well, the court's going to give it to that child, to that person, as long as they are safe, if they're the surviving parent. So it is important for anyone with a minor child to have that provision in a will.
Yeah. And I want to go back a little bit to the reading of the will. There is not a jurisdiction that I know of where it is required to have a reading of the will. So we all see that on television, but absent the court, there is no reading of we don't read the will. the court reads the will. So there's not a requirement for that. Unlike having designations for what you want to happen with your minor children. Also, in a will, you can decide how your debts and your taxes will be paid. In other words, you can distribute assets in such a way that it's done in your will. And debts, when a person passes away with a will in place, then debtors or creditors have an opportunity to come forward. If you have designated everything that you have outside of that, then that essentially says this is how my debts are going to be paid. Also, there is a requirement for a deceased person, for their people they leave behind, somebody has to file a final tax return. And so you can make information regarding how you want that taken care of in your will.
And then we talked here about you can designate the person that will represent you in taking care of your estate. So you want to make sure that you usually have more than one person mentioned, because you don't know their health and their particular situation any more than your future. So you want to make sure that you have multiple people, successors, designated, so that there's someone appointed that you trust and that you want to handle that responsibility. And you can also decide in there if they need to not post a bond. If you leave it blank, the court might require them to post a bond because they are handling property, and the court might make them go through some extra measures that you may not want that person to have to go through. So you can take care of that yourself.
Right. Yeah, such as they don't want to have to pay for that bond, a lot of times comes into play. Also, going back to the debts and the taxes and minors, if you are acting as a custodian for minors yourself, for instance, this could be guardianship custodian, and it could also be custodian of their assets, their monetary assets, or if they have become the owners of any property by nature of someone else passing away and they can't get it until they're of a certain age. If you're the custodian for anything when it comes to a minor child, grandchild, someone not related to you, under especially the Uniform Transfer to Minors Act, then you have to, in your will, designate who your successor is going to be. If you pass away, now who's going to be the custodian of those assets for that minor? So you have to put that in the will, that way that minor and that custodial account or any custodial or guardianship issues that are out there are taken care of within the will. So are there different types of wills? Different types of wills. Let's talk about that. Essentially, there are three main types of wills. And I'm sure that Keith has people come to him every day like I do, and they say, oh, I just need a simple will. Okay, most of the time they say that and they don't really understand what that means. And we tend to downplay what we have when a lot of times people actually do need more than a simple will. So the first type of will out there is a simple will. And this one provides for outright distributions of your assets. In other words, if you own a couch, a floor mat, $2 in a bank account, and you have a fur coat, and that's all you have, you leave those four things in the will. You say where you want each of them to go. Those are outright distributions. It's a simple will. There's nothing else to distribute. You don't have any other debts. You don't have any other assets. That is a simple will.
And the second type, this happens a lot, is we have wills where we design them to have trusts that are created at the time of your passing. So they're not in existence until you pass, but as part of administering your estate, rather than giving someone property directly and outright, you create a trust at that moment to hold that property for them. Some of the reasons you might do that is if someone is potentially on government benefits and you're thinking, okay, if I give them property outright, it might disqualify them for certain things like SSI, Medicaid. If you have a situation where someone is potentially in your mind a little bit immature with money and you don't want to give them something right now, you might want to put some conditions on that and hold it and have it managed. And then you might also have some situation where you have some tax things you might want to do, some tax planning, and there's certain Internal Revenue Code rulings of how you have to leave things in a certain way. So there are other reasons besides the amount of stuff that you have that determines whether or not you want to create a trust. It just might be the nature of the beneficiary that you're actually leaving the property to that dictates whether or not you give it to them directly. And then we also have a pour-over will. And the pour-over is if you actually create a trust while you're alive. Many times you might have heard of something called the revocable living trust. And it's marketed a lot of times that, well, if you do a living trust, you'll avoid probate. Well, that's partially true. You'll avoid probate on the things that are funded into the trust while you're alive. But what happens is inevitably people have a trust. They might fund some things. Some things are still in their owned in their own name. So you need a will, and the will have some terms that say, at my death, put anything that I didn't get a chance to fund during my life into the trust that I created previously. And that's called a pour-over will. And that is definitely very essential if you have a revocable living trust that you created during your lifetime.
Absolutely. And here shortly, when we get to the next part of this, we're going to talk a little bit about why it's called a pour-over will, because you have to have a will in place. So what happens if I don't have a will? And this is exactly a great segue into that. What happens if you don't have a will? Essentially, the laws of intestacy kick in and the state gets to decide. So in most states, if you die without a will, your property will be distributed according to what are called state intestacy laws. And intestacy is the legal term for without a will. And so this is why it is paramount for everyone from the time they turn 18 years old to have a will in place. And actually, in some states, you can draft a will at the age of 14, but you can't be a witness on anyone else's will until you're 18. So know the laws in the state where you're domiciled is what dictates how old you have to be to have a will in place. Everyone should have one in place. That way you do not fall prey to, or your family is not susceptible to the laws of intestacy kicking in. And those laws say if you don't have a will in place, we get to decide how all of your assets are distributed. Even if you still only have those four things, something has to happen with those four things. And they can be the same four things, they can be different four things, they can be any number of things. But the laws of intestacy kick in when you do not have a will. So that is why a pour over will is an excellent tool to accompany a revocable living trust, because you can distribute your four things that you have in that trust, and you can give instructions in that trust for what you want to happen with them, and you can be extremely specific on what you want to happen with each of your four items. I don't know why I'm stuck on four today, but four things, right? In your trust, you can say what you want to happen with those things. But if you leave those four things in a trust and you don't have a will, then those intestacy laws will come into place. So that's why it's called a pour over, because now rather than having your will and your trust, you have a trust and you have a will, but your will is pouring all of those four things that you have into the trust. So that way you don't pass away without a will in place, and therefore kicking in the intestacy laws.
And I want to mention, just so people understand, when you have the intestacy laws, they're giving property directly to those people. So you lose the opportunity. I mentioned this, if you wanted to do any kind of protection for someone who had government benefits, or if you wanted to put something in trust because you think they might blow the money because they're not responsible, or if you have any kind of tax planning you want to do, all those opportunities are lost, because when you don't have a will, the state just says, who is it? And just gives it to them. So if they had any benefits that they were trying to protect, they're gone just by the fact that they were left something by someone else. So even if they try to undo it, it still might cause them a problem. So avoiding intestate status is very important. You may not think of it for yourself. Obviously, you're going to be beyond the grave, but it's important for those that you leave things to, maybe not to leave them something directly. So you want to make sure that you take those steps with a will to leave something to someone in the right way.
Right, right. And also, if there's certain people that you want to specifically exclude, you can't do that if you do not have a will in place. So you fall susceptible to that occurring if you don't have a will. The intestacy laws, generally speaking, they give your property to your closest relatives. And closest relatives, they begin with a spouse, and then they go to children, and then it goes outward. If you don't have a spouse or children, then your grandchildren, it will go either to your grandchildren or up to your parents if parents are still living. So every state has a chart, and it's literally a chart that says if this person dies without a will, it goes over to these people, or whatever the chart is. The chart is different in each state, so just be familiar with whatever that looks like. But generally speaking, it goes to closest relatives: spouse, children, grandchildren, up to parents, out to siblings if you don't have children, spouse, grandchildren. And in some states, siblings can be a whole sibling, it can be a half sibling. Some states it doesn't matter, as long as it is by birth or adoption. I know a lot of times in many communities, we have play sisters and play brothers, and that cousin that you thought was your sibling because they were raised by your parents. Well, unless there has been a birth or adoption making that person in the same line of succession that you are, they may not be counted. So again, this is another reason to have a will in place. If you have that person that you raised, but you never formally adopted them, or they were not born to you, but you want to accommodate for them upon your passing, you have to have a will in place. Otherwise, they may not be on that chart for the intestacy laws, and they won't receive anything.
That's actually correct. I'm glad you said that, Shannon, because I have stepchildren. So many people out there with blended families, your stepchildren are not automatically included in these intestate laws a lot of times. So if you want to treat a stepchild like a child, you have to, only way you can do that is to have a will and specifically state that. So if you pass away, they will follow bloodlines, or like Shannon said, adoption. They will not go the next step of trying to figure out how you felt about someone. So it is only going to be a cold, like you said, a chart. So if you have stepchildren that you want to take care of, you absolutely need a will.
Right, right. Those cousins, nephews, nieces, all of them have to be in the will and specifically named. Otherwise, the court, once they exhaust that list and go down, if they can't find any living relative, then who do you think gets that property? The state gets it, because there's not a living relative that falls on the chart if you pass away without a will. So again, just another extremely important reason for having a will in place. All right. So what happens if you die without a will? We just covered that. Are there limits to a will? And can a will do everything? No, it cannot. And let's talk about what are some of the limitations to a will.
Well, the first thing is, we're obviously telling you to put everything down in writing, and there's a limit on, we have a legislature in each state that makes rules, and a lot of these rules want to protect spouses and children, in particular, if someone passes, from being destitute or being in a bad situation where they have to rely on the state. So you often cannot disinherit a spouse, or in some cases in the state of Georgia, it might be minor children that have an action for protection. So even if you say, I leave everything to the University of Georgia because you love your school, the state will step in and say, no, we require a minimum to go to your spouse, because that is in the public interest, the public policy. So what you put down on paper does have its limits if it clashes with some law that a state puts in. And like Shannon said, these vary from state to state. So most states have either community property that is already in place, so you don't really need to do anything with the will. But many states that are not community property states have a elective share for a spouse. And there's only one state in all 50 states that does not have either community property or an elective share to protect the spouse. And that state is Georgia. Sure. So we live in that one state that doesn't protect spouses directly, like most states do. But Shannon knows that there's an action that we can use called year support, which is available to spouses and minor children, but you still have to follow some rules on timing and other things. So it is a situation that a will have some limitations on what it can pass.
Yeah, I want to clarify that a little bit. Keith is absolutely right. There are many states, we just happen to live in one where it doesn't offer those protections. But the spousal rights, the other states that have that, they have what's called an elective share that a surviving spouse is automatically entitled to. Georgia doesn't have that. Also, in Georgia, you can disinherit your spouse. But the only way you can do that is to have a will that says that. And so there are absolutely laws on that. The year support essentially shows that somebody passed away without a will, and you need support from their assets in order to make it through. So what they do is they give you a year. It's kind of like that grieving period. Here's a year. Here, we're going to support you for a year from the assets of the estate. And that will give people time to figure out what all is in the estate, essentially. It's not always the best thing, especially if there's minor children. That is usually a good thing. But sometimes you have to weigh your options on whether even filing for a year's support is necessary, or even if there's anything in their estate to support for that year's time. So all of these things are things that people should absolutely consult with a estates and trust probate attorney on making those decisions. These are things that you should not try to navigate on your own. So also, a will does not govern the disposition of property. And we're talking about property that's real property, land, houses, anything that has a title to it, real property. So you cannot effectively leave things only in a will, because those are things that have a deed attached to it. And so the probate court can't just look at the will and say, oh, okay, this says so-and-so gets the house. Here you go, you get the house. Here's the keys. Well, it's not that simple because of that piece of paper called the deed that's attached to it. And so in some states uh, they have what's called a transfer on death deed or a ladybird deed. They call them different things, where you can have your will say something and then you have the deed attached to it that says, upon my death, this is the will, the property continues on to this person. Georgia doesn't have that. There are a couple of other states that don't have that as well. So your will doesn't govern the disposition of property. Also, the disposition of property where there is a named beneficiary already designated. So any sort of account that you have owned jointly with someone else, if it has a survivorship attached to it, that is designated. It goes automatically to the survivor. Anything that's got payable on death that already says upon death, this is where this is payable to, that's a designated beneficiary. That your will doesn't cover that. Life insurance policies, if they have a living person named as the beneficiary, those aren't, because again, those are things that you've already designated who they go to. That brings me to the point of people should always revisit issues, because if you, for instance, have that life insurance policy in place and the person you named as the beneficiary is now deceased, then you pass away without having changed that, now that policy becomes a part of your estate and it has to go through probate to go to anyone. So anything with the named beneficiary on it is not controlled by the will.
That's a great point, all those different things, because I have a case right now where it's a probate and the gentleman passed, and in the probate he had two different special bequests to his grandsons for $50,000 each, and he named a particular account from Wells Fargo. He did that will when he was single. So when he got married, he put that account in joint status with his new spouse. So what happens? Those $50,000 gifts go away because that account is no longer part of his probate estate. It never comes into play. So the will that's leaving $50,000 to these grandkids is not going to be able to be available. So of course now the mother of the grandchildren, who's not my client, thankfully, is not happy. And needless to say, is not going to be pretty, because she's thinking in her head, I guess, dad told, hey, there's going to be $100,000 coming to your kids, and now it's going to look like someone's pulling a fast one. But it's not. It's just that he didn't arrange his affairs in the proper way of coordinating the will with the beneficiary designations outside of the will.
Yeah. Absolutely. And then too, also, this kind of goes back a little bit to having that trust in place, because if you have specific designations that you want to make in your will, but it's outside of the will, if it's going to be outside of the will, put it in the trust, and then make sure you have a pour over will that references the trust. That way, all of your documents, and there are many in the estate planning process, but they should all communicate with one another, so that what you do in one doesn't take you off of the road on another. And this is also where you should always revisit any beneficiary designations that you have in place. But other limits to a will.
Before we move on, that beneficiary designation check is critical too, because you hear all these horror stories where someone gets divorced and they never took the ex-spouse off, and that beneficiary designation winds up sending some hundreds of $1,000s to some ex-spouse. And so you want to, when people say they want to take care of their affairs, the first thing in their mind is, all right, I get a will. No, you have to do estate planning, and you have to look at every single thing that you touch and see where it goes. And that's why you really have to have the help of a professional to really track all these things and make sure it goes where you want it to go.
Yeah, I've been on the unfortunate end of seeing that when that doesn't occur. One time too many, where an ex-spouse was the named beneficiary on a life insurance policy. And this was either an ex-spouse or a widow, and then they had remarried, and new spouse, regardless, knew about the policy, but didn't know that they were not the beneficiary. And so it's really not pretty when somebody thinks, grieving is hard enough, but when you add insult to injury on that, it makes the grieving process so much more difficult. So have your affairs in order, like Keith was saying, so that your loved ones can grieve without having to worry about the business of probate. So how do we do that? You have that will in place. And how do we execute or sign a will? There are rules that say, in order for this to be a valid will that will be recognized by the court in the jurisdiction where you're domiciled at your death, this is what that will must look like. It varies between probate courts. It varies between states. And so know what your state, where you are domiciled when you write that will, know what that state's laws are. Usually there's really not a lot of rules about how to sign a will. Some states allow you to have what's called a holographic will, which is a handwritten will. We have stories now. Aretha Franklin had 3 holographic wills. Originally they thought she didn't die. They thought she died without a will at all. And then later on, about a year later, they found 3 wills, 3 handwritten wills. And so they had to put a halt to the probate proceedings and verify the authenticity of those 3 holographic wills. So some states do allow it, a handwritten will, but not all do. Let's go back up. I just kind of skipped to that. Know what property you have when you pass away. When you write that will, know what you have. And again, things change. So updating your will often is a great idea. And this is what you can do when you have the capacity to do it. And those are the things that go in your will.
Absolutely, you have to sign the document, of course, but you also need to have witnesses to your signing it. And there's some, differences on states of, I know in Georgia, if you are a witness and you were given property under the will, you lose whatever you were given. So you want to be careful about who you ask to witness the will, or if you're a witness, be careful of what you sign for, because you might wind up losing some interest that you have if you violate those rules. So you want to know those particular rules. We as attorneys always, at least I'm pretty sure most of the estate planning attorneys, also include a self-proving affidavit. So your will itself has to be witnessed. The will doesn't actually have to be notarized. So it's valid when it's witnessed, but when we mentioned when you pass, we're going to take the will to the court to have it proved. So in that process, if there's not an affidavit that we add to the process, the court will say, okay, well, we see the witnesses' signatures on here. Bring one of them here to verify everything was done correctly. So needless to say, you don't want to have that happen because the witnesses may A, be dead, unavailable, or some other issue. So what we do is after we sign the will, have people sign, we make an affidavit that has the testator, the 2 witnesses, and then the notary will say everything was done correctly, the signatures are valid, and you attach that to the will and keep it with the will. So that when the person down the road passes away, you include that affidavit with the will, and that together allows you to go through the process pretty quickly. Because I've had a situation where someone came with a will from California, and California doesn't require an self-proving affidavit with the witness's signature. You can just do an attestation clause with just the person making the will. So they wound up coming to Georgia, and the judge here said, well, we don't have an attestation clause, affidavit, go find the witnesses. So luckily that law firm happened to use some associates, and they didn't still work there, but they could track them down. So it took about a month, and they found them, thankfully. So we could at least get a probate going, but you definitely want to think not only about the witnessing, but make sure you have that other self-proving affidavit for practical purposes.
Yeah, I'm glad that worked out for you. I had the exact opposite happen where the person came here, had a will that she had written in like 1978 or something like that. It was like 40 years ago. And she passed away here. It did not have that affidavit attached. We had to go back to the original drafter of the will, who was an attorney who wasn't even practicing anymore. He said, I don't really remember that person. You couldn't read the signatures. And then the names were typewritten under. If the names hadn't been typewritten, we would have had no idea. And he said, I don't really know who that is either. So then we had to do a Google search looking for these people. One of them was deceased. The other one was no longer at the address that was on there. We had to track her down, like literally had to get a private investigator to find this person so that we could probate her will here in Georgia. It was a mess. And so, yes, make sure that your will is properly executed by the laws in the state in which you are living at the time.
And also, I want to mention, Shannon, I'm glad you said 1978 because people need to understand your will does not expire. So if you make a will at 18 and you pass away at 80 and never made another one, then they can still use that will from when you made it, the last one you made. So you might just want to make a new will just to have the most recent expression of your desires, because they will pull out a will from 30, 40 years ago if they find one, and it will be valid if all the steps are appear to be done.
Yeah, yeah. Oh, which leads us to another question that I don't think we have in here. But where do we store a will? What do I do with it after I've written it? Do I have to keep it in a safety deposit box? Where do I store it? You should store it anywhere that you store documents that are important in your life. If you keep those in the sock drawer, that's where the will should go. You know, is it required that it be in a safe that's waterproof and fireproof? No, it's not required. It's a good idea, but there's no requirement that says that. So you should store it wherever you keep all of those very important documents. And you should let whoever your named executor is know where it is so that they, upon your passing, know where it is. I always think about my grandparents every time because they had a safe at the end of the hall in the closet with the towels, the linen closet. And it was on the bottom shelf, the safe was. And when they started getting older in age, both of their vision started changing. So they made sure that that safe was never locked. And always said, if anything happens, our wills are in the safe. It's not locked. The combination isn't on there. Well, after my grandfather passed away, somebody, I don't know who, somebody went in there and turned the lock. And we couldn't get into those documents. So we had to write to the Century Safe Company to get the new combination for the safe to get in there and take them out. Yeah, okay. They were right. They should have been stored in there with those really important documents. But it didn't help that grandma couldn't remember the code and somebody locked it. So again, make sure when you do that, that it is accessible to whomever. There's a question. Can you also scan a copy to yourself? Would that be invalid? What if your copy is destroyed? Great question. And go ahead,
You need
please.
an original for the court. So just to be clear, you need originals when it comes to wills. We have had talks about prior seminars where we did advanced directives and power of attorneys. Those you can make copies of, but your will, the court's going to want an original. And only if you lose the original, can't locate the original, and then they can try to verify the copy. So you want to operate from the frame of thinking that you're going to have only original documents when it comes to a will.
Yeah. Yeah. The courts require you to go through extra processes when you are not offering the original for probate. And they're like 40 extra hoops to jump through. So it is best to have that original copy. All right.
And
So what happens if you want to change your will?
hold on,
You,
I saw Rashida had her hand raised. She poked the hand right up. I didn't know
okay.
she had a question.
Yeah, I do have a question, but it relates back to the last slide in regards to notarizations. Have those rules changed? And because of COVID, are people allowed to notarize documents based on viewing them through video chat and scanning documents back and forth?
That's a great question. And the answer to that, short and sweet, is no. Georgia, especially for estate planning purposes, the court did allow remote notarizations, but via video. However, the witnesses and the testators still had to all be able to see and hear each other sign, and they still had to all sign in the same day. And so it made it very challenging. So yes, they did allow it because of COVID to be done via video, but that didn't erase the requirement that they all be within earshot and vision.
Remember, a will doesn't need to be notarized.
Right,
So,
I understand.
Yeah, just to make sure. So that remote notarization, that would be from other legal documents, and then the self-proving affidavit would need to be notarized, but that doesn't even need to be done right away. It's not a self-proving affidavit can be done later. So if you're just doing a will document that you need to get done, as long as you have the witnesses, you're good. So then that kind of takes away some of that,
Notary.
issue with COVID and notarization for a will.
So it only applies, so the remote notarization, for the lack thereof now, no longer only applies to other documents, but not necessarily for wills anymore. Is that what you're saying?
No, I'm saying wills don't require notarization at all. The actual will itself. The
Well,
only
right.
thing.
But if
Right,
they were
so-
going to do, if they were going to do, or even the self-proving affidavit, right?
Right, the self-proving affidavit required a notarization. So that they would still have to do those methods, but you don't need to, there's no time frame. So if I do a will in January, I could do a self-proving affidavit if I want to in March if I needed to. So because you don't have to do it right away, it kind of makes it you can probably just work out meeting in person or do something around it. It's not kind of the immediate need to do it right then and there.
Right.
So the witnesses still have to be, they have to still be in the same room, or at least be able to see the person signing, and you said hearing them to actually sign the will. Is that correct?
Right.
Right.
Right. When I do, generally speaking, my documents, rarely do I just do a will. And so anything else that requires a notary or anything, it's all part of that same signing process. So I just kind of go across the board on everything. But Keith is absolutely right as far as the self-proving affidavit and how that has to happen. I've seen some really crafty ways of people getting documents signed in the midst of COVID and the restrictions.
Yeah, I've just met with people and just kind of made a safe space because I don't want to go through all those steps. Because when I saw what you had to do, especially if you have a long document and some of these documents could be 30, 40, 50 pages, it's just like, you know what, I'm not doing all that.
I did too, and I said no more. I literally sat in my car in the client's driveway. I dropped the documents off on the front porch. Then I got on Zoom. The witnesses were on Zoom. And the first one was kind of fun. I was like, oh, this is really cool. But after that, I was like, oh, I'm not doing this anymore. It became very cumbersome. So what happens if you want to change your will or revoke it? Revoking means you take it back. And can you do that? The answer is yes, you can do that anytime prior to death, as long as you are still of sound mind. And so what can you do in order to revoke it? In most states, you can expressly annul it, meaning you say, this will no longer exist, here's the new one, or even this will no longer exist, and now I'm gonna just die intestate.
Yeah, I think the common thing is, I'm pretty sure Shannon does this. When you make your will, a lot of times you'll just have a sentence right up front, I revoke all prior will, because if you leave it blank and you don't specifically revoke, then the court's kind of like, all right, if you have multiple versions, then we have to compare and contrast and see if you have some things addressed in one that's not addressed in the other. So a lot of times for practical purposes, we're going to say we revoke it, but you can, of course, destroy it if you rip it up or burn it. Probably be better to burn it, because if you rip it up, someone can try to find it later and say, oh, well, they didn't intend to do this, and then you have a whole litigation. So if you really want to destroy it, you probably want to burn it. and not leave any trace of it. We have we kind of talked about codicils in there, so you can have an amendment where you change something through a codicil and say this is a codicil and I'm changing this, or you can make a new will that is just completely different. So I think the safest way is to, like we said here, just revoke it and make a new one. Just say I'm revoking everything else I did before. I'm starting from scratch. Here's my new thing. Because if you do it any other way, you're asking for someone else to come in, especially who's going to do it? Someone who was less in the more recent version, right? Because if I was given more in an earlier version and the second version that comes out, I'm given less, I have every incentive in the world to challenge what you did. Mm-hmm. So you have to keep that in mind from the practical point of view of who's going to object to whatever changes you make.
Absolutely. You're so right. Who's going to challenge it? It's going to be that person that doesn't get what they thought, such as that ex-wife or ex-husband. All right. So what happens when you divorce? If you and your spouse divorce, then the will language that specifically leaves property to that spouse is automatically revoked by the courts in most states.
And that is, I'm trying to think that happens after the decree, I think, or it actually does happen when you're actually going through the action. I'm still not sure on that.
The action of filing that divorce.
Filing,
yeah.
Okay.
Yeah.
So
it's the action of filing because that stay order goes in.
Right. So if you pass away after the action started, but before it finished, they still get that property taken away. So yes. That's a good thing for those to disincentive. Hey, just get to the courthouse and don't procrastinate. Just get there, and because you never know, God forbid something happens in the middle of something.
Yeah, yeah. I had a client who.
Are you with me? I saw my internet was unstable.
Yeah. I had a client whose husband passed away in the middle of their divorce proceedings, and it stopped everything from the probate. Whereas if she were his spouse, she would be able to file the probate action with no challenges and everything. But she had to check different boxes on the probate action because he died in the middle of their divorce, and so that took away some of her rights, even though on paper she was still his spouse because they were not yet divorced. But it takes away those rights. So yes. Any language that names your spouse is revoked in the will. Keith, you want to talk about what happens if you remarry that person?
Yes, I was going to say I think the divorce is where people automatically think, okay, I know something should happen. If I make a will and then I get divorced, they're thinking that person should probably be removed. But they don't think that if they were single and then they get married, that their will should change necessarily. That might not occur to them. So, can you go to the next slide? Okay. Yeah. So, in many states, in Georgia, if you have a situation where you made a will, left property to someone other than the spouse that you wound up getting married to, and you did not specifically say in the will some language saying you're making this in contemplation of being married, then when you pass away having never made a new will, so you get married and then you pass away having not made a new will after you got married, Georgia will step in and say, okay, when you made that will, you obviously didn't take care of the spouse because you didn't have a spouse at the time. So we're going to put in some kind of mechanism that's going to take care of that spouse and give them what their share would have been in an intestate situation. So even though you have an actual will in place that doesn't name them, the state will step in and say, no, we have to give them something. And how do we calculate that? Okay, let's give them what that spouse would have had if he or she, if the person passed away intestate. So if, for example, if they had one child, the person passed away, had one child and a spouse, the spouse will get 50%. So that even though if the will said, I leave everything to my child Johnny, and then they got married, that spouse will get 50%, and then the will would then be distributed according to whatever the person said. So that's a very important thing if you get married, to then remake your will after you get married, so that there's no question of what you would have wanted it to be.
Yep. So once I have a written will, am I done? Is that the end of it? No, absolutely not. You have to make sure that other documents when it comes to estate planning are in place, like that power of attorney, like that healthcare directive, like a trust if that applies to you. All of those documents are all part of your estate plan. So just the will alone in some situations is not going to suffice, especially if something happens and you become incapacitated. The will has nothing to do with that. So you have to have the rest of those documents in place. You should also revisit your will periodically. I think a good marking point is annually, around the same time that you authored it, just to make sure that it is maintaining pace with your plans. Like it's making sure that your goals are still intact. It's making sure that your life still falls in line with your goals and your interests when it came to what you wanted when you did that will. And sometimes the laws change. So making sure that your will stays in pace with the laws. If you move, making sure that your will stays in pace with the laws. All of those things that occur in our life. I like to tell people anytime the 5 Ds, which are divorce, disability, disqualification, meaning you had a job and you were getting all of this insurance through that job, and now you no longer have that job, so you're disqualified from that plan. Departure, meaning you retire from a position, and death. Anytime those 5 Ds collide with the 5 Fs, faith, family, fitness, fun, and finances, anytime that collision takes place, it is an excellent time to revisit your will. Yeah, and I always like to tell people, I have a story where I had a client who wasn't married, did not have any children. She left everything in her will, everything like in charge of her power of attorney. She was leaving everything in the hands of her nephew. And then her nephew got into some pretty serious trouble and found himself serving a life sentence. And so the next year when I called just to check on her, see if anything's changed in life, have any of those D's and F's collided, she says, oh, do you think it's a problem that my nephew is now going to be in jail the rest of his life? He's serving a life sentence. I said, is this the nephew that you left everything to? Yes, absolutely. Excellent time to revisit your will, revisit your entire estate plan, and put other things in place. So, sometimes things happen. Sometimes things happen. If 2020 didn't show us that, then I don't know what does. But things happen and we have to pivot and reevaluate and readjust. And so your estate plan, especially your last will and testament, should not fall by the wayside on all of that pivoting and readjusting and planning.
And also I would say, Shannon, also not only who you're leaving things to, but in that will, you're going to mention executors who are going to serve over your estate, maybe trustees for the trust you create. So if their situation changes or they pass away, you might look, if the guardian of your minor children, if they passed away, now you don't have a guardian of your minor children. So it's not only the property, what you're leaving, you have to look at people in their roles. And if someone gets Alzheimer's that you anticipated on serving in a couple of roles, you now have to revisit your will because you need to update who's going to serve. So right. You really need to constantly check your situation and the situation of the people around you that you named to do certain things in those wills. Right.
I see a question in the Q&A. If one has life insurance policy, is it added to the will? The policy itself is not added to the will. Life insurance policies have a named beneficiary. And so that is something that passes outside of the will, outside of the probate process.
Well, it usually does, unless sometimes people name someone and then that person's not available, so they passed, they didn't have a contingent, or some people actually put to their estate for some reason. So usually it won't, but you can. But it's not your will that it goes to. It goes into your probate estate. So,
Right.
Just to be clear, your will does not take effect until you actually die.
Right.
Another question? I see.
I'm sorry. Yeah, quick question. So you're saying if you have a life insurance policy, you left it to some a beneficiary who predeceased you, it doesn't go to the predeceased person's estate, and it goes back. It reverts back to the person who made it, the insured.
The
It
beneficiary.
follows the designation form. So if you have someone who's the primary, you hear me? Yeah. So if you have someone who's the primary and they passed away, then the contingent that you named, it would go to the contingent. And if there's that contingent passed away, then sometimes the actual company or has something in there that says if there's no person that's named, then it's like a default that it'll send it somewhere. But it doesn't go to that first person who passes. No, it goes to the contingent that's on the form.
Okay, so what if the contingent has passed away as well?
Then it is.
Then it goes to
owner.
the next person or the default.
Repeat that. I'm sorry.
It goes to the owner of the policy's estate. If all of the named beneficiaries have passed away, then it becomes an asset of the estate of the owner.
Okay, thank you.
Yeah,
but also that question was
right now.
Yeah, and that's why a lot of times we'll ask that people don't name people directly, especially if we mention having a trust in place, that you name the trust, because that way, if you're always going to be able to pay it to the trust, and then the trust can have provisions that say these are the beneficiaries, or so it would be just that primary payer is the trust rather than an individual, and then that trustee receives the funds and then handles it from there. So you never have that situation where money gets lapsed like that.
Right. Right. Are there any other questions? We're about out of time this evening. Again, thank you all for attending us.
Yes.
I had one quick question regarding Georgia in property. You said that you cannot name the property in the will. Is that like if I have a house and I want to leave it for my wife or son, where do I state that?
Oh, no. You can name property in the will, but it only passes if it's only in your name. So if you're the only person if the deed is only, you own it 100%, then you could pass it by will. But if you had a situation where the deed was in your name and your spouse's name and it's joint tenants with right of survivorship, that means the moment that you pass, your 50% interest automatically passes to the other spouse. So that would have no effect in that particular situation. But if you own that piece of property, whether it's your residence, a vacation home, business, anything that you own 100% in your name, or just a piece of it only in your name, even if it was tenants in common. If you own that house 50-50 tenants in common, where your 50% piece passed by your designation, then the will control. So you have to know how things are titled.
Okay.
Yeah, I think that what I was saying with regard to that is you can put it in the will, but it's still going to have to go through probate because of the deed that attaches that property. The will is not what says who owns the property. Whoever you name is going to have to go through the probate process in order to get the deed changed to now have their name on it.
Okay, that makes sense. Thank you.
Great question. Any other questions?
Do you guys work on high net worth from high net worth clients and trust and estates, especially for trust?
Yes, I do.
Okay.
And that was what we mentioned, some of those that will that had the testamentary trust, and a lot of those times we'll have bypass trust and Q-tips and all that stuff. That tax planning would be an example of the testamentary trust will.
Correct. And we always refer people to their tax planner, their tax professional, their financial planner. We all realize that it's a team. And what we do on the estate planning end should never counteract with what somebody has done on the financial planning end for them. So I always work with the team of people to ensure that the entire plan is comprehensive.
And many
Thank you
times we're going to get a
both for
referral right from the
information.
financial advisor. Sorry, do you need? Yeah, so the financial advisor a lot of times is the one who's going to make the referral. So they might be sitting in the meetings because then you're kind of working with the financial advisor right up front because that's where the referral came from.
Right.
So it's been a lot of times.
Yeah, I'm asking because I'm actually studying for my Series 7 now.
Okay.
So
Mhm.
I'm looking for people that I can count on,
Mhm.
like attorneys, to be part of that network.
Right. Yeah, it is absolutely a team effort. All
So we
right.
might have to have a second conversation later.
Absolutely. So here's our conversation links. You can reach out to Keith and or myself. Not only can you reach us via the iCaba World network, but our personal information is on here for introductory purposes. Keith is at the Georgia Elder Lawyer, and I am at Legacy Legal ATL. If any of you have any questions, feel free to reach out to us. You will also be able to review this webinar on the iCaba World community site in a couple days' time. And if there are no further questions, we are going to call that a wrap on tonight's session. Again, thank you all for attending. Thanks for your questions, and we look forward to helping each of you create a legacy.
And hopefully we'll see you next month because remember every month we're here on the third Tuesday. So next month I think we do the For the Love of the People. I'm not exactly sure exactly what we're going to talk about, but hopefully you can be here and join us in February for that.
Will we get an email reminder?
Yes, and I'll try to post on, we'll definitely post on iCaba World and then our LinkedIn sites and other things. So we'll try to definitely get the word out as quickly as we can.
Well, thank you so much.
Thank you.
Thank you,
Thank
Keith.
you all.
Thank you, Shannon. Have a good night.
Y'all have a
Right.
great evening.
Good night.
You too.